However, we are asking that you give him that chance. My client is not a child anymore. He's an elderly man at this point.
Into the plea bargain agreement, it's a cap of 6. The state is remaining silent on your application. 2021 CR 4788, State of Texas versus James Lawrence Stegmeyer. Could I have parties announced for the record for the state,
Michael Villarreal for the state.
for the defense?
John Coons for Mr. Stegemeyer.
And are you Mr. Stegmeyer?
Yeah.
Are you Mr. Stegmeyer? All right, you entered a plea to count 3, which is indecency by contact. You entered a plea of no contest on September 13th. There was a request for a PSI report, TAP evaluation, and MIG-MILF evaluation. And of course, through the nature of the offense, he's not going to be eligible for MILF. But have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Yes, Your Honor.
Defense? Any objections to the PSI report, state?
No, Your Honor.
Defense?
No, Your Honor.
According to the plea bargain agreement, it's a cap of 6. The state is remaining silent on your application. All right, defense, is there anything you wish to say on behalf of your client?
Judge, if you'll recall, this is an individual who I struggled with, not with him personally, but because he had been diagnosed with dementia about 20 years ago by the VA. This is something that I had him evaluated for. Dr. Scott did at least one evaluation. I provided numerous documents to Dr. Scott and to the jail where my client's been sitting for the last year and a half or so. Unfortunately, unfortunately, Dr. Scott found him to be competent and did not see the same issues relating to my client's Parkinson's that the VA did. With regard to all of that, obviously I trust Dr. Scott, having known him. He's been around for a long time, and I understand his evaluation. I had him actually reevaluate my client based upon some additional information that I provided. He sent back a further evaluation stating that it didn't basically change his opinion of things. At that point, Judge, my client and I decided that the entry of a plea would be in his best interest. Judge, it's never easy for you to have things like this in front of you with victims and especially someone that was at the time. I would tell you, Judge, though, that
Excuse me, I'm sorry, just one moment. All right, yes.
okay. Let's see, where was I? With regard to cases like this is obviously difficult for a court to even contemplate probation sometimes. However, we are asking that you give him that chance. My client is not a child anymore. He's an elderly man at this point in his life. And given all the health problems that he's had and with the Parkinson's, with the other issues that he has, I don't think he'll be any sort of danger or risk to the community while he's on probation.
So counsel, does he have dementia or does he not have dementia?
Well, so he has Parkinson's, and the VA has diagnosed him with Parkinson's related dementia. This goes back approximately 20 years. Again, as I was telling the court earlier, I provided all of that documentation to Dr. Scott. Dr. Scott met with my client and had determined on 2 separate occasions that my client is not incompetent. So, I'm not sure what I'm supposed to do beyond that. And the reality, judges, I have not seen maybe the signs of dementia that would cause me to request a second doctor to evaluate. Dr. Scott did the 2, and
Excuse me, Deputy Laura, you've dimmed the lights on us. You've dimmed the lights.
so,
Yes.
Judge, I would ask that you do give him the opportunity to be placed on deferred adjudication. He will have to register.
I'm sorry, Deputy Laura, you dimmed the lights. I mean, there's a lot of things wrong with it, but I mean, we are close to October 31st. Okay. All right, yes.
So, Judge, again, with regard to my client's sentence, we're asking that you give him the opportunity on deferred. He will have to register as a serf. We understand that. He understands all of the conditions that he will have to comply with. The probation will not necessarily be easy for him. This is, again, with his health issues. I do believe that a placement in the MIC unit, if that's possible, would be very beneficial to them. The one last thing I'd like to point out, Judge, is that the complainant did not communicate with the probation department. I know that that's not necessarily something that can be examined one way or the other, but this is not a complainant who is raising Cain with the court or raising Cain with the DA's office about what should happen to them. So I would ask that you, given all of the information that I've provided to the court, that you consider that my client's application for deferred adjudication and place him on the deferred.
All right, Mr.
Okay.
Steck.
I know we're silent, but just as a factual issue, the victim is here after sentencing to provide a victim text.
Okay. All right. And so, Mr. Stegmeyer, I want you to know that I've listened to what your attorney has said. I've internalized it. And I have read and combed through the PSI report to review everything. So what I can tell you in this court, and I think your counsel knows this, for me, I look at each case individually. It does not concern me, or I don't take into my consideration of sentencing whether there's media, not media, because to me, each case is supposed to be looked at individually and sort of in a vacuum of that case. The same way I tell jurors not to pay attention to anything that's on the news, I do that as well. All right. Is there anything you wish to say?
No.
All right. The court is going to deny your application. The court will find you guilty. The court will sentence you to 5 years in the prison, give you credit for any time served. There's to be no contact with any minor children, no contact with any of the complainants in this case, or the complainant's family, and Chapter 62 compliance. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review this document with your attorney? Did you understand it? And did you sign it?
Ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yeah.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. You said there's 2023 CR 10633, State of Texas versus Devin Heflin. Could I have parties announced for the record for the state? Defense?
Or Alexander from Meredith Chacon from Mr. Hill.
And are you Mr. Heflin?
Yes, ma'am.
Any objection to this attorney standing in for Ms. Chacon? All right, so what is happening, Mr. Heflin, is this is an attorney that works in the same firm as your attorney, Ms. Chacon.
Yes.
My understanding is that a plea bargain agreement has been worked out between Ms. Chacon and the state. All right, so Mr. Chacon probably had to go to another court. So this attorney is standing in for her. My understanding is that this attorney is not here to change your plea bargain agreement. He's just here as an attorney standing in for Ms. Chacon so that the plea can be completed. If you would like, we could wait for Ms. Chacon to come back, or either you can go forward with this attorney. Which do you prefer?
You said you work with her or we're in business together. So you know all her cases though?
Yes. She was mine.
All right, do you want to speak with him?
Yes, ma'am.
All right, if you all will step back and talk to each other. Okay,
Sorry,
all right,
I had to take comments.
no problem. And for the record, for defense?
Meredith Chacon for the defense, Your Honor.
All right. Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your
Court will find that the state is in compliance with discovery. Is there an application in this case?
Honor. No, Your
All right, Mr. Heflin, I'm going to show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am. I did understand it.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor, we do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Going to show you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am, I did.
Did you understand you're charged with aggravated assault with a deadly weapon? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Heflin, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 7 years in the prison, and there are no applications. And I see outside the agreement, there's a request for an affirmative finding of family violence. Did you understand if I find that there's family violence and that this is a case of family violence, and I enter an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition? Did you understand?
Oh, yes, ma'am.
And did you understand you would not be allowed to be designated as primary custodial parent? Did you understand?
Yes, ma'am.
And also, if I find that there is a deadly weapon involved, there will be an affirmative finding of deadly weapon. Did you understand?
Yes, ma'am.
Did you understand that to be the entirety of your plea bargain agreement?
Yes, ma'am.
State,
Yes, ma'am.
defense.
Yes.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the agreement, the state is requesting no contact with Kaydin, Kaydin Butler and James Butler, affirmative finding of deadly weapon and affirmative finding of family violence. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Stand up for State Exhibit 1 with all attachments. Your Honor, we have no objection. I have gone over the attachments with my.
All right, I'm showing you the waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Also, I forgot to ask, are y'all proceeding on both counts?
Yes, Your Honor. Yes.
And are you pleading no contest to count 1 and count 2?
Yes, ma'am.
And are these counts to run concurrent?
Yes. Your
The court, no problem. The court will review states exhibits 1 and attachments for sufficiency. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. My client was on a parole that had been transferred here to Bear County and would like you to give him credit for that time to run concurrent as well. The state had no objection, is my understanding. No, Your Honor.
All right, and which, do you have a cause number or anything?
You might.
And the court will find you guilty of count 1, guilty of count 2.
And for the record, Your Honor, the victims are also aware of this, Your Honor, and in agreement with this. And I do have the case number whenever the court is ready.
Okay. Count 1 and count 2 will run concurrent. And then what is the cause number for parole?
19 CR S 238347. It's out of North Carolina.
All right, and the court will give you credit for any time served in that cause number and credit for any time served, of course, in this case. There's an affirmative finding of deadly weapon, affirmative finding of family violence. There's to be no contact with Caden Butler and James Butler. And I'll sentence you to 7 years in the prison. Is there anything else with regards to sentencing from either side?
No, you're not.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea, because I followed your plea and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed, and also a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. How old are you?
20. I just turned 21 2 days ago.
All right, so I don't know what was going on with you at the household or what's going on with you in your life. If there's a mental health issue or anger issues, that's something that you're going to have to work on. Otherwise, you may find yourself living in a prison. You understand? And when you get to the point in Texas where they stamp you as a habitual, that means in some cases your minimum sentence is 25 years. You understand? All right, do better, okay? All right, good luck to you.
A 21-year-old defendant walked into Judge Stephanie Boyd's courtroom expecting a plea hearing, but left with a life-changing lesson. After pleading no contest to aggravated assault with a deadly weapon, he accepted a plea agreement that carried a 7-year prison sentence. Before imposing the sentence, Judge Boyd carefully explained every consequence, including the permanent loss of firearm rights and the serious impact of a family violence finding. Once the court reviewed the evidence, she formally found him guilty and sentenced him to 7 years behind bars. But Judge Boyd's strongest message came after the sentence. Looking directly at the young defendant, she warned that he was still young enough to change his future, but only if he took responsibility for his actions. She explained that continuing down the same path could eventually label him a habitual offender, where even the minimum prison sentence could jump to 25 years. Her final words were simple yet powerful: do better. It wasn't just a sentence, it was one final opportunity to change the course of his life.